Phyna, the ex-BB Naija star, dropped screenshots of her private IG and WhatsApp chats with Israel, Davido's head, after he messaged her asking her to stay away from his ex-wife, Sheila Courage. The DMs revealed Israel venting about his failed marriage and stating that until they returned my bride price, Sheila was still his wife. He also raised heated claims of his ex-wife's infidelity, a chat Phyna called out as hypocritical and disturbing. She lashed out hard on X and IG. Israel is a bastard, a very useless man.
Bastards, animal, woman rapper, bender.
She didn't stop there. She shared every relieving snippet in IG stories and comments. Then Israel struck back by doxing her, posting Phyna's phone number and branding her as untrustworthy for sharing personal chats. While fans are divided, with some outraged at Phyna for violating privacy, others see it as justified exposure, being that she refused to stay silent about being told who she can hang out with. Now, when is sharing private chats crossing the line? Let's look at what the law has to say. In today's interconnected world, sliding into DMs is the new normal, whether on WhatsApp, Telegram, Instagram, etc. Social media direct messages has become integral to personal and professional interactions. While these platforms offer convenience, they also raise critical questions about the privacy of our conversations and the legal ramifications of sharing them without authorization. The big question becomes, what happens when those private chats go public? Can you legally expose someone's message without their permission? Let's talk about the fine line between receipt and serious privacy breach. Let's start with case example. For instance, Instagram posts various screenshots shared without redactions, revealing personal exchanges between individuals. And number 2, X posts, public commentary about conversations including private matters, sparking online debates and digital tracing of involved parties. These incidents reflect a growing culture of receipts without legal awareness. Now let's talk about the legal foundation of this. Number 1, right to privacy. The fundamental right to privacy in Nigeria is enriched in Section 37 of the 1999 Constitution as amended, and it states, I quote, "The privacy of citizens, their home, correspondence, telephone conversations and telegraphic communications is hereby guaranteed and protected. This includes text messages, DMs, WhatsApp chats and emails. Any public disclosure of this without express consent may violate constitutional rights." The law explicitly guarantees and protects the privacy of citizens, their homes, correspondence, telephone conversation and telegraphic communications. Number 2, interpretation for digital age. While drafted before widespread digital communication, courts have generally interpreted correspondence, telephone communications, and telegraphic communications to encompass modern forms of digital communication, including private chats. Unauthorized sharing of these communications can be seen as a direct violation of these constitutional rights. Number 3, Nigerian Data Protection Act of 2023, NDPA. This is the primary legislation safeguarding data in Nigeria. Personal data includes phone numbers, which serve as a digital or online identifier of a data subject. Sharing such data without informed, explicit, and documented consent is illegal. Section 25 of the Act prohibits processing or publishing personal data without the consent of the data subject. From the fact above, the chat published by Phyna revealed Israel's phone number, and Israel then went on to post Phyna's phone number, hence making them equally liable for breach of privacy. Now let's talk about the consequences of this. Number 1, civil penalties of up to 10 million naira. Number 2, the data subject may claim compensation for damages. The question then is, will both of them be claiming and counting claims against each other? I would love to see how this plays out in court. My lord, if I may I? Now let's talk about civil liabilities. If your private chat or conversations was published without consent, this amounts to a tort that can be pursued. You could file a complaint with the Nigerian Data Protection Commission, NDPC, and also apply for a court order for content takedown or damages, or institute a civil action for breach of privacy. Courts can grant remedies such as 1, injunctions. These are orders to stop further sharing or publication of the private chat. 2, damages. This is known as monetary compensations for reputational harm, emotional distress, and financial losses incurred due to the privacy invasion. Number 3, defamation. If the shared private chat contains false statements that lowers the reputation of the individual in the eye of the right-thinking members of the society, a defamation lawsuit can be initiated. Now, what can be considered lawful? Number 1, you can share personal information provided you have the consent or approval of the party or parties involved. Number 2, for the sake of national security, prevention of crime, or for the greater good, you can share private information, but first, you must still obtain an authorization that overrides the right to privacy of the other parties involved. Finally, sharing private chat might win internet clout, but the flip side of such clout must be considered, especially where it is at the expense of someone's dignity, rights, or even your own legal safety. Unauthorized sharing of private chats, whether intentionally or not, can lead to severe legal ramifications, including fines or civil damages. In an increasingly digital world, respecting privacy and understanding consent are not just ethical considerations but legal imperatives. So now, let's talk. Have you ever had your private conversation revealed to the public without your consent? How did you react? How did you feel? And how did you deal with it? Let us know in the comment section. Don't forget to like, share, and subscribe for more content like this. This is Legal Essentials, Kenudo, signing off.